So a bit of an overview of our presentation today on protecting your brand internationally. We'll do a quick intellectual property 101, a few basics, then we'll launch through a bit on trademark registration and particularly the opportunity for Madrid Protocol registrations. We'll then deal with a little bit of infringement of trademarks and then a bit of a discussion on proactively protecting your brand internationally and rather than being reactive, trying to get on the front foot. So I guess firstly, what is intellectual property? We've got a bit of a diagram here which represents some of the forms of intellectual property, sort of broken down into two broad categories under industrial property and copyright. The focus of today's presentation will mainly hit on trademarks and protecting your brand through trademarks. However, there's a whole gamut of other aspects of intellectual property. We've hit up on some geographical indicators. We've touched on copyright. There's obviously a wealth of other works rather than just literary works that come under copyright. But yeah, as I said, today's focus will be mainly on trademarks and trying to protect your brand in a proactive rather than a reactive sense. So, in respect of trademarks, what is a trademark? Well, in its simplest sense, a trademark is a distinctive sign that identifies your goods as being provided by you. So, obviously, you can turn your mind to lots of famous trademarks or signs that identify brands. Obviously Coca-Cola, you think in wine, Penfolds is a pretty strong trademark with a distinctive Latin script on that sort of italicised, stylised script. Now, in terms of ownership, the owner of a trademark has exclusive rights to the use of the trademark. It's often common for those rights to be licensed out, for trademarks to be licensed for use by third parties, whether it's your distributor or other agents. And a trademark that is registered can be protected from infringement. And I guess that's the key, is there can be common law or unregistered trademarks, but we'd highly encourage you to seek registration of your trademarks to get that protection. So, moving on to registration. I guess we're focusing from an Australian perspective to begin with. And registering your trademark within Australia provides protection only within Australia. However, there are two different ways that you can, that Australian trademark owners can seek trademark protection overseas. Firstly, you can file an application directly in each other country or other market that you're seeking to become involved with, or you could file a single international application through IP Australia nominating various Madrid Protocol countries in which you're seeking registration. So that can be quite advantageous in that it might save you some time and some costs rather than filing directly in each country. You lodge one application via IP Australia in Australia or via your other international trademark office utilising the Madrid Protocol. And I guess one of the keys there is whichever option you choose, you'll still end up with separate trademark applications in each country ultimately. It's more of the administrative burden that can be alleviated through a Madrid Protocol application. So what is the Madrid Protocol? Madrid Protocol was a treaty that provides international registration of your trademark, and it's administered by WIPO. And put simply, it's a method of facilitating the filing of trademark applications in a number of countries simultaneously. Now, all requests for protection in Madrid Protocol contracting countries are examined according to the domestic trademark legislation of that country. So obviously there are wide-ranging variations amongst trademark laws in different countries, so you need to be aware of that. And I guess the next question that flows is, well, what countries are members of the Madrid Protocol and what markets and what access would a Madrid Protocol application give you? Well, there's some 90 plus member countries that are have signed up to the Madrid Protocol, including some of the big export destinations, certainly for Australia, being the US, the UK, Japan, quite a bit of China, excluding Hong Kong and Macau. As I sort of touched on earlier, one originating application can be lodged through IP Australia or your local trademark office without the need, at least initially, to engage local counsel in each jurisdiction. Now, in considering whether you should use the Madrid Protocol or whether you should do a direct application, I guess there's a couple of questions you probably should consider. If you're seeking registration in many countries, the Madrid Protocol application can save you some time and costs. However, one thing to keep in mind is it's linked to your original Australian registration. So if they kind of all link back to that original Australian registration. So that's something to keep in mind. Also, another important point is, if opposed, you probably need to engage local counsel to get specific advice for the jurisdiction that has an opposition lodged in it. Obviously, there's many intricacies of various countries' trademark laws, and getting specific advice at that time is probably highly advised, particularly if an opposition is launched, can get quite complex. On the other hand, if you're only seeking registration in 1 or 2 markets, it might be more appropriate to seek a direct registration or application in those countries rather than lodging a Madrid application. Particularly if you're only dealing with 1 or 2, it probably won't save you that much more money, and you'll have that direct access and the specific advice in country for those 1 or 2 markets. Following on from that, a successful Madrid Protocol application doesn't mean an automatic approval of every trademark in every country that you've indicated on the application. As I think I touched on briefly earlier, each application is reviewed by the local trademark or IP office for potential conflicts. So the Madrid Protocol simply streamlines that application process. So there's quite a lot of, administrative advantages into using that method. However, it's quite important to consider the unique law of each country. For example, a Madrid Protocol doesn't necessarily allow the same level of detail that you might if you registered direct in country. For example, we're aware of some subclasses of goods or services not being available in a Madrid Protocol application in China that you might get access to if you had a direct registration. So I guess the caveat in all of this is it's probably a good idea to seek some advice in country when you're seeking to file a trademark application to see if the Madrid Protocol application will be suitable or whether it's more suitable to seek a direct registration in that country. And following on from that, giving, I guess, a US example, US trademark law can be notoriously stringent as to the language that is required to describe the goods and services that you're offering or seeking to trademark, as well as the classes that you're using to designate that particular service or good offering. And also they require quite a lot of specific details when describing the product. So again, this is coming back to seeking some advice. Getting advice early might actually save some cost later on if you get the right description and get the right service and class offerings, rather than perhaps filing a Madrid Protocol application and then finding out there might be an issue with it and having to seek further advice and to remedy that issue. But all in all, there are advantages in using the Madrid Protocol, particularly if you've got a lot of countries that you're seeking to register under. But it's a good idea to seek some advice before you launch into it. I'll now hand over to Girish, who's just going to briefly run through some kinds of trademark infringement.
Thanks, Tim. For the purpose of this webinar, we're going to canvass 3 main areas of trademark infringement. The first category is that of direct infringement. This is a broad term that encapsulates various forms of direct infringement. In Australia, a trademark infringement could be prosecuted under three sources of law. First, under the Trademarks Act. This is an act specifically designed to protect brand goodwill, and it is therefore likely to be most applicable to your circumstances, that is in the import or export of alcohol. The second type of direct infringement is under the Australian consumer law, and the third is under what is known as the common law. These last two have less application, but are worthwhile being aware of nonetheless. The second there is parallel importing. This is a huge and very complex issue and probably deserves an entire webinar in its own right. Many, if not all of you, will have experienced parallel importing in some shape or form. Whilst many would argue that it is healthy for an economy and creates some sort of competition, when it comes to your brand, parallel importing definitely has its dangers. And the final type of trademark infringement that we'll cover is that of squatting. Many of you will have registered trademarks in your local countries, and squatting is a process by which people in other countries take advantage of the difference in trademark registration rules across countries. The obvious example is China, where there have been some high-profile cases of trademark squatting resulting in millions of dollars worth of settlements. So in Australia, the goodwill in a trademark is protected by the Trademarks Act. This Act regulates all aspects of trademarks, from registration to preservation and infringement. In Australia, if you suspect your trademark has been directly infringed, you must satisfy the elements in Section 120 in order to be successful. Broadly, three things need to happen. First, your trademark must be registered. An unregistered trademark will not attract the protection of this Act. And second, the infringing party, or the party who you claim to be infringing your trademark, must be using a sign as a trademark. This second element is not a requirement in the relevant US law. So as an example, if you see an advertisement where it looks like someone's using a sign that is deceptively similar to your trademark, if they're not using that sign as a trademark and merely as a descriptive sign, then you're not likely to have recourse in Australia, but you may do in the US. And finally, the sign must be substantially identical with or deceptively similar to your trademark. The second broad source of law that may apply to trademark infringement is under the Australian consumer law. Section 18 provides that a person must not, in trade or commerce, engage in conduct that is misleading or deceptive, or is likely to mislead or deceive. This legislation is aimed at protecting consumers and really finds its application in how goods are advertised, irrespective of the use of trademarks. So for this reason, broader factors are also relevant in assessing whether someone is deceiving or misleading, being things like the type of market in which the goods are being sold, the manner in which they are sold, and any disclaimers attached to them. Often in Australia, you'll find that if someone feels their trademark is being infringed, they'll bring an action under both the Trademark Act and Australian consumer law for misleading and deceptive conduct. It's really a process of casting the net a bit wider for a better chance of success. So the third and final form of direct infringement is passing off. This is an old tort that has little application in Australia due to the remedies available for trademark infringement and misleading and deceptive conduct. The reason for this is that you must show that your trademark has an amount of goodwill or reputation attached to it, and that you have suffered loss as a result of the infringement. So we just have a broad example here. This picture here shows a Chinese counterfeit of Treasury Wine Estates Penfolds brand. Apparently this bottle turned up at a Chinese wine show, complete with marketing material featuring Penfolds chief winemaker Peter Gallo. This is quite an obvious example of a counterfeit product, but in most cases you might even have to open the bottle to figure out whether it's counterfeit or not. So this obviously involves the making of a false representation It's designed to make a consumer believe that goods are those of another, and knockoffs like these free ride the reputation of established brands. So we come to the second type of trademark infringement, parallel importing. As we said earlier, this is a huge and very complex issue and probably deserves an entire webinar. In simplistic terms, parallel imports are brought into a territory by parties other than the usual agent. So this means that there is a product that is ultimately being imported without the permission of the IP owner. So we see here in this flow chart, the top line represents the traditional flow of product from producer through an importer and or distributor, depending on where you are in the world, through to retailer. The bottom part of the diagram shows a simplistic version of parallel importation, whereby the retailer sources your product from an unauthorised reseller instead of the distributor with the rights to import your product. The reasons for parallel importation are quite simple. Price. Importers can take advantage of differing price points and profit through arbitrage, and retailers can pick up stock at prices way below what they can get them through proper channels. So a parallel import is a non-counterfeit product imported from another country without the permission of the IP owner. This is the reason why parallel importing is so vexed, unlike other forms of trademark infringement, which involve largely counterfeit products. Parallel imports are real. Customers in most cases are not being misled or deceived and receive the real product at lower prices. So this creates what is known as a grey market, which is largely unregulated. Advocates of parallel importing view it as a method of creating competition, and consumers enjoy the ability to purchase premium products at substantial discounts. But for producers, there are significant risks involved. Provenance is a huge issue. In most cases, there is no chronology of ownership, custody, or location of the product. Quality control is therefore an issue. Storage conditions are unknown and unregulated. You might not even know how many countries a product has been shipped through to get to the end point. So all of these culminate in a reputational risk. Any infringement of your trademark is a threat to the goodwill in the brand. In 2012, Huon Hook wrote an article on executivestyle.com titled Perils of a Parallel Universe. This is one of the thousands of articles written on this topic, but one which I came across yesterday. In it, he describes parallel imports of bottles of Bollinger advertised at a large local retailer in Australia for $57 at a $27 discount to the usual retail price. This was $10 cheaper than the licensed importer could purchase a bottle for through his staff discount. The retailer was unaware of where the bottles had come from or the conditions in which they had been stored, but at those prices couldn't resist the bargain. The point of the article is that parallel importing drives down the price of a product to such depths which ultimately lead to reputational damage. Seemingly in response to that article, Tyson Seltzer, an esteemed champagne writer and a recent presenter at the Australia Trade Tasting, tested each of the 7 champagnes that a retailer was parallel importing against legitimately imported versions. This was a blind test by 2 MWs, 2 retailers, 1 writer and Tyson, and the results of the test were that there was no discernible difference in the champagnes. So the point here is that whilst there is a lot written about poor storage conditions and transport conditions of parallel imported goods, on the quality side of things, maybe there isn't much to worry about. Nonetheless, there are risks to your trademark, and you can protect your IP by placing obligations on your distributor in your distribution agreements. So briefly, some of the things you might want to cover in a distribution agreements are placing an obligation on a distributor that they will only promote and sell your product in a clearly defined territory during the term of the agreement, that they will not register trademarks anywhere or at any time. They will represent themselves as acting only as a producer of your product, as your importer. They will not alter labelling or place their own stickers on packages without consent, and they won't make false or misleading representations regarding your product. Finally, if anything does go wrong, you want your distributor to inform you promptly of any suspected breaches of IP and provide you with assistance in dealing with it. I'll just hand over to Tim for the rest of the presentation.
Cool, okay, now we're going to deal with a bit of trademark squatting. Obviously, Girish has cited a couple of examples already of some trademark infringements, but I guess we'll have a bit of an introduction into what trademark squatting is. It's where a person registers your trademark in another country, potentially in bad faith, and quite often it's used to hold the legitimate user of the trademark in another country to ransom before they are able to get that trademark in the second country. We've seen a lot of it, particularly in China, where China actually uses a first to file system as opposed to a lot of other countries which have a first to use system. So I guess the story there, or the lesson there, is that you've got to get in early into China to try and protect your brand because they've got this first to file system. And I guess the accord of that is the first to file has priority over a prior user of the trademark who hasn't actually registered the trademark. To give you a bit of an example, we seem to be harping on about Penfolds quite a lot, but they've actually, unfortunately for them, had quite a few cases where they've been involved in infringement. Penfolds had registration in China for various Penfolds trademarks, including the Latin script trademark that you can see in the top left-hand side of the slide. The owners of the Penfolds brand, Treasury Wine Estates, unfortunately failed to register the Chinese name Benfu for Penfolds in China that had become associated with the Penfolds brand. So even though they had various trademarks, the kind of the translation, if you like, Benfu, hadn't been registered. A fairly notorious trademark squatter actually registered that Chinese name Benfu, which by the by roughly translates towards dashing towards wealth, which was quite a good translation for Penfolds, I think, in terms of how they were seeking to position their brand as a sort of a luxury product in China. And unfortunately, Treasury became involved in protracted litigation to try and preserve the integrity of its brand in China and to, I guess, get back control of the Chinese translation Benfu. I guess the other lesson back on Penfolds there is that if you're seeking to get involved in China, it's worth pursuing a Chinese character trademark as well, and seeking to, I guess, spend some time maybe with marketing people in China to come up with a good name and a good Chinese character equivalent to your brand. We've had experience here with some of our clients going into China, and in our experience, it's something that's worth getting right at the start and spending some time working out what some compatible translations might be. I know it might seem like an onerous task, particularly when you're starting to enter a market, but I guess one of the themes of this presentation is trying to be proactive rather than reactive. And I don't think anybody wants to have to get in the position that Penfolds are in trying to get involved in a dispute to maintain or retain control of their brand. The next element of this presentation is just going to focus on a quick case study, particularly focusing on the Australian market, but it relates to the case E&J Gallo Winery and Lion Nathan Australia. It was involving a US brand, Barefoot Wines, which I'm sure many of you are familiar with, particularly if you attended the Australian Trade Tasting Conference. We had Michael and Bonnie, who were the original founders of Barefoot Wines, give us a bit of a story of their brand, which was quite fascinating. Anyway, Gallo, the massive US winery, purchased the Barefoot brand quite some time ago now, and became involved in this case involving the Barefoot wines and an Australian beer produced by Lion Nathan called Barefoot Radler. So, a bit of background, Gallo was the registered owner of the trademark Barefoot in Class 33 in Australia, which is in relation to wines. Lion Nathan had applied to register the trademark Barefoot Radler for beers and other goods in Class 32 in 2007 and began selling that beer under that mark in about 2008. Now, the Barefoot Radler product is a beer made in, I think it's a German style, which has got sort of a citrusy lemon lime addition to the beer. It's quite a refreshing kind of summer style. So Lion Nathan thought they were onto a winner. It would work well in the Australian market, and they had, as you can see in the top of the slide in the pictures, this kind of footprint with the Barefoot Radler mark there. Which is obviously pretty similar to the mark that Gallo or Barefoot had originally in the US and had registered as a trademark, as a word mark in Australia. The issues, Gallo commenced proceedings alleging that Lion Nathan's use of that Barefoot Radler mark had infringed on Gallo's Barefoot mark, contrary to Section 122 of the Trademarks Act. Lion Nathan counterclaimed that Gallo's Barefoot mark had not actually been used during the 3-year period from 2004 to 2007 and therefore should be removed from the register in accordance with Section 92(4)(b) of the Act, sort of their non-use argument. So, a couple of findings from the full court. They found that beer and wine were goods of the same description. So this is a really important finding, is that beer and wine will be seen to be basically in the same description. So you can't make the argument that we're producing beer and that's separate and distinct and a consumer will be able to tell the difference. For the actual purposes of the Trademark Act and what the court found, that beer and wines were goods of the same description. Lion Nathan's Barefoot Radler mark was deceptively similar to Gallo's Barefoot mark, and that Lion Nathan's use of the Barefoot Radler mark was likely to deceive or cause confusion. So that was the findings of the full court. Lion Nathan applied for special leave to the High Court on these issues, but was unsuccessful in gaining special leave. I guess in respect of the non-use aspect of the case, this is quite a fascinating element of the case, and kind of gave us some guidance about what use will actually constitute in Australia. Bit of background, Gallo had an international distribution agreement and in 2001 shipped about 60 cases of the Barefoot wine to a German company who then in turn sold that wine to an Australian, actually a Victorian liquor wholesaler in 2002. So it was only 60 cases of this wine that went to the German company. I think it was about 41 bottles maybe at the end of the day that actually ended up in Australia. The Australian liquor wholesaler marketed and sold a number of the bottles during this 3-year alleged non-use period that Gallo had contended. However, there was no evidence that Gallo actually knew that the wine that they'd given to this German company initially was being offered for sale in Australia under the Barefoot mark. However, the full court was not satisfied that there was use. As for use of the trademark to occur in Australia, there must be a conscious resolve on the part of the person alleging ownership or future use in Australia. Gallo actually appealed that decision to the High Court, where it concluded that it was not necessary to show that the goods bearing the mark had been knowingly projected into the Australian market by the registered owner, and accordingly, there had been use. So a couple of key takeaway points, I guess particularly for US brands that are coming into Australia or have got trademarks, Australian trademarks. The trademark owners seeking to rely on evidence of use of their mark in Australia will not necessarily need to show that such use is the result of a conscious intention on their part to sell the goods bearing the mark in Australia, where such goods remain in the course of trade in Australia. And secondly, the owners of a trademark registration for wines in Class 33 can prevent the use of registrations of the same or similar mark for beer in Class 32, and accordingly vice versa. And accordingly, it will be continue to be important for trademark clearance, or when you're searching for an application or potential application in Class 33, to include searches in 32, which is the category for beer. Now we're just going to have a bit of a discussion on being proactive in protecting your brand. So there's a couple of reasons that we think it's important to get on the front foot. And there's some steps that we think brand owners should be taking to be proactive. Particularly, we think you should have a full range of IP rights in place before you enter into the market, or just before you're entering into the market, to ensure you have the ability to act swiftly and effectively against any problems that might arise. Part of this is having a bit of a pragmatic understanding of the market and its potential risks. So actually having dialogue with your distributors, having dialogue with experts in the market. I know in Australia we've got access to Wine Australia and the various satellite offices that Wine Australia has around the world, in the US, UK, etc., etc. That's, I guess, good business practice, is to log in and use those resources that you've got to understand how your brand might be perceived in the market, and to do that, proactively. Further, we'd recommend that you have a discussion with your distributor about how you're going to proactively protect and promote your brand in country. And in that regard, split up some of the division of labour between yourself and your distributor. If your distributor can help out in feeding you information about what's going on in the market, whether there's any potential conflicts or infringements, obviously we would encourage that. Your distributor obviously is going to have a lot of relevant knowledge in country of the market and what's going on. You can't be in country all the time. So that's obviously an extremely important and we think valuable relationship to foster, and even to codify sometimes in your arrangements about reporting obligations of your distributor. So when you're having your, whether it's quarterly meetings, there's some dialogue on that. And next, we'd also encourage you to have some kind of program in place to monitor your distributors in all markets for leakage, theft or other violations of the distribution agreement. So this can be kind of like a health check that you have, I guess, having an independent party that you might be able to check up on your distributor on a kind of regular basis to make sure they're keeping in the spirit of your agreement and following through what they're promising to do. Following on from this, there's a couple of practical things that you can do. Firstly, before you actually get into market, or before you're actually setting up your brand, or once you do have your brand, monitoring social media, checking Twitter, Facebook, Instagram, claiming your brand on those platforms, rather than waiting for somebody else to create a Twitter account with your brand and then having to salvage or try and rescue it. Get on the front foot and register a Twitter account with your brand. It's also a good way of seeing and following what's actually being said and who's using your brand out in the big wide web, World Wide Web. And on that regard, make sure you're on the front foot and claiming your brand on those platforms rather than having to retrospectively try and reclaim them. And also be proactive, make sure you're aware what classes your goods are registered in respective trademarks, when you need to renew your trademarks, and also being aware, as we kind of have already touched on, of what the use requirements are in the relevant market. Now, these can differ between various markets. Obviously, in Australia, there's non-use provisions, but we'd highly encourage you to actually be aware of what the use requirements of your relevant market are. So I guess in summary, a couple of takeaway tips in respect of protecting your brand. We highly encourage you to register your trademarks in Australia and also other jurisdictions that you're going to trade in, and do that early. Being proactive in respect of protecting your brand. And as we discussed sort of quite early on in the presentation, there's the opportunity, if you're using multiple jurisdictions with your trademarks, to consider a Madrid Protocol application. And I think, as we discussed earlier, that doesn't necessarily mean you shouldn't consider direct registration in each of those countries, but there are some potential cost and admin savings in utilising a Madrid Protocol application. We've sort of discussed some of the problems that you might come into with your brand in international markets. There's counterfeiting concerns, there's trademark squatting. Being proactive and being aware of what's going on in your market is so important. Having that direct line of communication through with your distributors, talking with your customers, being active on social media and monitoring the use of your brands is just so important. And lastly, seeking advice, whether that's through lawyers or seeking good accounting advice in terms of making sure you've actually got your numbers lined up before you launch in country. Seeking professional advice is of course recommended by us, and that might mean getting recommendations from your local lawyer as to experts in other countries. They might have agency arrangements that they've got contacts and connections with in various other countries that you can seek to get some specific in-country advice that will arm you before you start dealing with another country. So I guess that's the conclusion of our presentation today. We've tried to keep it short, sharp and shiny as we can, as a bit of a quick introduction to some of the things you can be doing to be proactive in protecting your brand. So if anybody's got any questions, we'd be happy to see if we can give a quick response on the chat. But otherwise, thank you very much for taking the time out in your day to listen to us. And thanks to Zach and the Beverage Trade Network for giving us this opportunity.